Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning, focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk to you about how Medicaid treats jointly held assets, particularly second homes. But before I do, I invite you to schedule a free strategy session with me at eldermeeting.com. Okay, so how does Medicaid treat jointly held assets, particularly second homes? This is a topic that comes up in my Medicaid planning, with my Medicaid planning clients. The families may own whether a lakeside cottage or a little farm or a beach condo or something of that nature, and it's jointly held by multiple family members, and it's been in the family for generations. And it's a source of stress and anxiety when a person needs to apply for Medicaid, as the family doesn't know how that asset's going to be treated. Are they going to be forced to sell something that's been in their family for generations? And so it's a real source of stress and anxiety, and I wanted to address that with you today. So if a client owns their home that they have as their primary residence, we all know your homestead, your primary home, doesn't count as an asset for Medicaid purposes. But what about that second home that you own with other people in your family? You just have a small percentage interest in it, whether it's a 50-50 share or an 80-20, or you're only a 10% interest holder. How does Medicaid treat that when we're looking for an application? And Medicaid knows that co-owners, you can't force somebody else to sell, right? Like, just because you're gonna apply for Medicaid and you need benefits doesn't mean that you can now force the hand of your brother or your sister or your child, your adult child, or an auntie, or whoever you hold this property with, and force them to sell. So if the asset can't be liquidated, it's not treated as an asset for purposes of applying for Medicaid. So that's the good news. It doesn't count if you're planning to keep it in the family for generations to generations. That's not to say that it's not something that you should be cognizant of or aware of, because if the person, the joint owner, passes away before the Medicaid applicant, recipient passes, now all of a sudden it's a countable asset, because the last man standing is the person receiving Medicaid, and now Medicaid will count it. So you do want to have some planning in place and know that it could become a problem in the future. It might not be a present problem. Also, if the family members that own it decide that they do want to sell it, they're like, no, it's time for this to go. It's too much burden to maintain, or what have you. At that time, if everybody decides that they're selling, then that again is a asset that is going to be countable to the Medicaid recipient. Whatever proceeds would be income to them. They can't just say, oh no, don't keep my, I waive my share because I'm a Medicaid recipient. They're not allowed to do that. So with that in mind, initially you can apply for Medicaid and be a co-owner, but it could cause a problem in the future if there is a change in the way that you hold the property. So I hope that this information has been helpful to you. If it has, I ask that you like and share with others, and feel free to schedule a free strategy session with me at eldermeeting.com. Thank you for joining me.